to Bodacious Estate Conversations, the podcast where we skip the polite small talk and get straight to the real story about handling a loved one's property. From unexpected challenges to the messy emotions nobody warns you about, I bring you unfiltered stories, practical advice, and clever shortcuts from people who've been there and the professionals who know the way. If you want honest answers, bold strategies, and the confidence to take control, you're in the right place. Here is your host, Casey King.
Thanks for tuning in on today's episode of Bodacious Estate Conversations. I'm excited to chat with. Our guest today has spent more than 25 years practicing law, helping families navigate some of the most complicated estate legislation and elder law challenges. He works in the creditors' rights and bankruptcy, trial and insurance, trust and estates, and municipal law practice groups. His real-life cases involve everything from property disputes and guardianship to uncovering financial abuse, legislating fiduciary misconduct, and helping families clean up estates that went very, very wrong. He's an attorney known for creative problem solving when things get messy. All right, so let's give a warm welcome to Michael. I'm thrilled to have you on Bodacious Estate Conversations, Mike.
Casey, thanks for having me. It's a pleasure to be here.
Oh, truly, the pleasure is mine. So today we're diving into something most people don't realize until it's too late. And that's how an executor can unintentionally mismanage an estate and the enormous financial consequences that follow. Stick around until the end because Mike will share a real case study where a power of attorney's choices resulted in a $76,000 judgment and the simple steps that could have prevented it. So, let's just dig right into it. Mike, when somebody steps into the role of an executor for the first time, which is most people, what is the most common way they could accidentally mismanage that estate?
Well, it's going to depend on what their capacity as a fiduciary is. You're referring to usually when someone's in probate, and either letters of administration or a letter's testamentary have been given, and that's someone who's taking care of the estate of someone who's died. The important thing there is that you have to realize that you're working both for the benefit of creditors and beneficiaries, and that's somewhat of a contest between the two because creditors want to get as much money as they can, beneficiaries want to get as much money as they can, but you have obligations to try and manage the estate assets in order to maximize the recovery for both. At the same time, you may also either be doing it as an act of goodwill because it was a family member. You may be acting as an appointed person, and you're entitled to a commission. So you also have to understand that you may have a financial interest in this as well, and you have to be ethical about how you handle things. Mm-hmm. One of the most important things in taking over a decedent's estate is identifying assets and creditors early, so you know what things are out there that need to be preserved and who's going to make claims against it. When you have real estate, obviously there could be liens either from mortgages or reverse mortgages, home improvement loans, things like that. And they usually have a higher priority than anyone else upon the real estate on which they attach. That doesn't mean they're entitled to anything else. And you have an obligation also to make sure that not only you identify assets, but that you properly preserve them. So when you get involved in some place and you know that there's something that is of value and has an insurable interest, particularly homes, but also things like cars or motor homes or vacation homes, things like that too, you want to verify what the insurance is. And when you're looking at things like that, one of the things that you have to keep in mind is that the premiums for a place that has an occupant can often be different than the premium for a place that doesn't have an occupant. So one of the things that you may have to weigh in the preservation of the assets, particularly real estate property, is do you want to keep people living in it for a while so that you could say it's an occupied property and get the benefit of a lower premium versus are these people who are likely to take advantage of living in the property in some way? Are they going to commit waste? Are they going to damage the place? Are they going to get people in there that you're going to have a harder time getting out later? These are decision calls that require judgment, requires you to have conversations with people to attain an understanding of what their expectations and your expectations are going to be. When you're dealing with a married couple where one partner has passed away and the other one's still living there, it's possible that their interest may pass through the title of the property rather than the estate. But there may be things in the property that otherwise need to be liquidated as assets that are not considered marital property or not considered, otherwise non-probate assets. So there's a lot of initial investigation you need to do. You also need to advertise the fact that the estate has been raised and there's someone in charge of the affairs as soon as possible. The reason why you want to do that is because it triggers a 1-year statute of limitation, at least under Pennsylvania law, for any creditors to make you aware of the fact that bills are due or there's debts unpaid. If they do not contact you within that year, you would be within your rights to not honor that debt after that time. So the ways you do that is you go through the person's papers, you interview family members, you try and find out what debts are outstanding. You can look at your local register of deeds to see if there's any liens on the property. You can have a title search done. There are a number of things that you can do to educate yourself. You want to take the opportunity to alert the post office that all mail should be filed and forwarded to your attention so that you're getting any notices that are coming in about bills being due or other debts. So there are a number of things that you need to do to identify both the assets and the debts immediately.
I'm sorry to cut you off. You said to advertise it so that creditors have the chance to reach out to you. How do they advertise that? Is that like local newspaper?
Yes. Every county has at least 2 periodicals that are considered the official newspapers that an estate needs to be raised in. So this will change locally, but it has to be generally a newspaper of general circulation for that county. So the way that I would typically do it is you identify which newspapers are recognized by the Register of Wills as the official papers for the county. You advertise it in that. There has to be 2 successive publications. And that's that, when you look in the newspapers in the classified section, you see estate notices. That's why everyone does that. They are putting the world on notice through publication that someone has died and anyone who owes them money needs to come forward. And you end up getting those ads and you certify to the Register of Wills that this has been done. This is part of all the paperwork that you will eventually need to file in order to have the estate officially adjudicated should it come to that. I personally will also send notice to any debt creditors that I become aware of just through going through the paper saying I am now in charge of the affairs of the estate of so-and-so. Please present me with a final demand for payment if there is one.
I see.
Now, depending on what things are, it's possible that some creditors will not only compromise, but may eventually forgive the debt and not present a claim. So
how often does that happen?
It depends on what it is. Credit card companies usually would rather have something rather than nothing. So you have some negotiating power there. If it's a creditor that has a secured debt, it's less likely.
I see.
A lot of medical bills often get forgiven upon death, and often, but not always, student loans, depending on how they were funded, can be forgiven on death. So there's a lot of opportunity for negotiation to try and save assets for the beneficiaries. Again, you need to go about asset preservations. Your responsibility is to make sure that whatever is there either maintains the value it has or increases in value until time of distribution. You got to be careful to try not to lose money or lose value of investments. So you want to make sure the insurance is addressed, that you have policies set up. This all assumes that there's available liquid cash, though. I mean, there's only so much you can do if you don't have access to liquid assets in order to do preservation. But with respect to covering potential loss or casualties that may arise, like, if someone dies and their house is left fallow and someone comes across the property, like a mailman, for example, trips and falls, you got a claim against the estate now. So you want to make sure that you have appropriate casualty and property insurance in order to cover that. You want to make sure that properties are secured against potential loss, like winterizing them, particularly if they're in areas where it might be more prone to snow and things like that.
Yeah.
And then with regards to investments, as you become aware of them, you have to make the decision as to whether you'll liquidate investments versus whether there's long-term gains that are better for beneficiaries, and then instead of liquidating financial investments, you instead choose to assign them as part of the state distribution. But if something is invested in a more risky type of mechanism, you probably want to look at that and move it to a more prudent investment platform. So there's a lot of responsibilities that kick off the moment you're put in charge, and you need to take immediate action. One, to let creditors know you exist and they have a limited period of time to present their claims, and two, to do everything you can to identify and preserve all the assets.
Yeah. So since you have a year, well, creditors have a year to come forward and stake a claim to the estate, should you wait to distribute funds?
My recommendation is yes.
Okay.
Yeah, I typically tell everyone I don't plan on, and I don't recommend you plan on distributing anything till after the year's over.
Mm-hmm.
So, you have a better sense of what the liabilities are and things like that. Now, you're allowed to pay expenses of the estate in order to maintain and preserve property. When you get to the point of distribution, the cost of maintaining the estate is a higher priority than debts of the estate.
Yeah.
Otherwise, the debts might not have anything to pay them. So there's in Pennsylvania, at least, there's the probate code has categories of what expenses are to be paid in what order. There's like all different categories. I could go ad nauseum about that, but generally, yes, expenses of the estate get paid before anything else, with a couple exceptions. So now, once you get a handle on everything, obviously, if you were appointed according to the terms of the will, your obligation is trying to, meet the terms of the will as stated. That can include specific bequests that people want to give, as compared to general requests. So, like, a certain Ming vase might have to be given to cousin Larry before any money is paid.
Okay.
Things like that. The other thing I recommend is that, if you're going through a property and you don't know what things are, that you get an appraiser to come in and take a look at and tell you what's junk and what's not. Giving something away to a family member not knowing it has its value is one of those pitfalls that could happen. Because, a lot of times the bric-a-brac in the house, it's like, who really wants it? You end up throwing things away. You can do that if you really think it has no value. But if you're wrong, you run the risk of being subject later to a surcharge. If you misuse, mishandle, throw away valuable things as a fiduciary, you can be subject later to someone holding you accountable and potentially paying damages for that loss.
Yeah. That's why it's important for people to work with folks like me or other people, appraisers, not appraisers. Appraisers. But I was thinking of auctioneers are good ones, because they'll only go through and take what they think they can sell. And you're getting the market value there, going to an auctioneer.
And honestly, never underestimate the ability of people to hide things in their house that are actually valuable.
Oh, yeah. I can't tell you the times we find things like inside books or, like behind filing cabinets in nooks and crannies. Yeah. We find
doors, behind picture frames,
Yeah.
all kinds of things.
Yeah. Yeah. People are funny. So, okay. Well, that's interesting. So what are things, as far as the funds from the estate, that people should not use that money for? Like some examples.
In a decedent state, you shouldn't be paying your personal expenses, obviously. I would encourage people to avoid giving advances. Like, just because someone has an expectation that they're going to get so much money under the will doesn't necessarily mean that in the end, once all the debits and credits are looked at, they actually get that.
Yeah.
And you run the risk of causing all kinds of problems if you pay advances. One thing I do encourage is that you should start looking at the probate inheritance tax return as soon as possible. And if you have the liquid assets available, paying the estimated tax early, as you might get a discounted amount, and using those assets more immediately to pay a discounted amount, you can avoid penalties and interest that you may owe later. So that's definitely one recommendation I have. Now, it's possible that as you go through things, you find more assets. That happens all the time. If that happens, you can file an amended inheritance tax return and just pay the additional amount. And if if they give you some pushback and they start trying to hit you with penalties or late fees and stuff like that later, you can explain the circumstances under which you couldn't find the assets before and ask them to waive it. And usually they can be pretty reasonable about that. To try to get a handle on that, on the whole asset gathering part, one of the things I always recommend is that people go to the Pennsylvania Treasury unclaimed property webpage, run the person's name. If you know that they had family members who died before them, they might have been a beneficiary, run their names too. My spouse works for a state representative, and she helps people process these claims all the time. And sometimes it's really silly things sometimes, but like $5-10 here from you used to rent video games from a company, and there was a refund that you didn't know about. But usually once a year we run the name, see who's out there, and let my aunts and uncles know, hey, you got money out there you can get back if you want it. So as an executor or as a power of attorney or as a trustee for something, for someone, you should probably do those searches at least at the initial state and also right before you decide to close the estate, just to see if there's anything that popped up.
Yeah. That's a good call.
Insurance premium checks is another one. If they send out an insurance premium check or some type of income to you and it doesn't get claimed and it goes back to them in the mail, eventually it gets to the state treasurer. So that's one resource that's out there that can help you identify other assets.
So I just want to run a scenario by you. So let's say somebody put in their will that they wanted certain funds to go for, an actual, let's say, to pay off college student loan debt. So there's a life insurance policy, and the life insurance policy's payout, according to the will, is to pay off somebody else's student loan debt. But there's no other funds in the estate. The checking account, savings accounts have been bled dry. There's nothing there. There's no other funds to continue paying the mortgage or utilities or maintenance for the property. Should those funds go towards paying off the student loan debt, or should we wait and hold the funds to maintain the property until it's sold? And then once the property's sold, distribute? Like how would you?
In this hypothetical question, I have to give a very qualified answer.
Okay.
The first issue that you need to understand is a life insurance policy is a non-probate asset, which means the estate does not get to touch the proceeds unless in the policy itself it says to pay out the funds to the estate.
Interesting. Okay.
So if someone had a life insurance policy and wanted someone to get those funds other than their estate, they should designate the beneficiary in such a way that the money would be used the way they want it to. Now, in the circumstances you're describing, the beneficiary who you really want to get paid is the creditor of the person holding the student loans. If you could appropriately identify that creditor, you could make them the beneficiary, and then they could make a claim against the insurance policy for the proceeds and ostensibly pay off the debt, accept it as payment of the debt. And that would never have to go through probate.
Okay.
If someone said in their life insurance policy that the beneficiary is their estate, then the money would just flip over to the estate, become an estate asset. Then you're dealing with the situation of the circumstances of the will. In the circumstances of the will, it would be creditors of the person who wrote the will who would have the right to seek enforcement of payment. It wouldn't be creditors of someone else. So they could make a beneficiary under the will be the creditor of the person holding the student loans, but that gift would still only be paid out after all of the expenses and debts of the estate are paid.
I see. Totally hypothetical question. I for sure do not have a real life scenario. Yeah. So in this hypothetical scenario, again, because there's no funds from the estate to pay literally anything, the maintenance of the property, the mortgage, the utilities, water's been shut off, gas has been shut off, we're facing foreclosure.
Mhm.
There really isn't anything we could do unless we could get the property sold before foreclosure hits. And so now we're looking at it just being an insolvent estate because there's no funds left.
Right. Insolvent estates are very hard to deal with. In a situation such as the one that you're describing, the executor or administrator of the estate has the responsibility to act as a reasonably prudent fiduciary to try and minimize the harm and maximize whatever assets are available. With respect to real property, the options could include trying to do a short sale, doing a deed in lieu of foreclosure in order to get a discharge of the debt, going to public or private sale, including potential auctions under a public sale. But you have to, and if you're going to do that, you want to make sure you have a reserve, because a creditor who is secured in property wants to make sure that they have the full amount. And quite frankly, under the certain circumstances, just letting it go through foreclosure, it can be a reasonably prudent thing to do. It depends on all the surrounding circumstances.
Right. Yeah, we tried to be creative with that one, but that at this point looks like it's the only real option we have is just letting it go. So, I mean, you've handled estates with dozens of heirs. What kind of mistakes do executors make in those complex, family tree situations?
It can be hard sometimes to make sure that you are quantifying someone's share of an estate correctly. I handled an estate where they died intestate. It was a married couple, and within a couple months of each other. And so first, in that situation, you had to decide who died first. That certificate pretty much dealt with that. And then, who are the heirs of the longer surviving spouse? Because in a spousal situation where there was no children, and this was the case, the other spouse took everything. It was real easy. But then the second spouse who died had, as I said, had no children. So in under the intestacy laws of Pennsylvania, you have to start going back up the family tree, and the parents had predeceased them, and then you start going down the family tree. And this couple originally came from Puerto Rico. They end up being part of the surviving spouse who died second had a very large family with extensive branches of people, some of whom had died slightly after her, some of whom died before her, and you had to determine who got what's share and trace it all back. And long story short, there ended up being 67 intestate beneficiaries who were across the country.
Oh my gosh.
So I was, and then you have to do the math right. So I was dealing with things where when we finally got to close an estate in Pennsylvania, you have to resolve it pretty much in one of two ways. One is called a family agreement, which is all the beneficiaries under the will or intestate get together and say, all these expenses have been paid, all these debts have been paid, here's what left. Can we agree to whack it up the way we agree? Even if it's contrary to what the will says, they can still agree to that because it's a way of resolving the estate. The second way is what's called an account and where the person who's the fiduciary, whether it be the executor or whether it be the administrator, says, this is everything that I gathered. This is how much it was valued at. These are all the debts I've identified. These are all the debts I have paid or will pay. These are all the expenses, and here's what's left over, and this is how I intend to distribute it to everyone. And unfortunately, because I couldn't get a hold of 67 different people across the country to get them to agree on anything, let alone some of them even to talk to me, I had to put together an account and say, this is how I propose to do this. And there were second cousins once removed, and there was this, that, and the other thing, and people were getting 137 of a share. And I had to do all the math, and you're rounding things off by the penny. And they don't expect you to be perfect in account, but they want you to try and account for as much as possible. And while the paperwork's pending in court, there's still interest generating, because it was a minor interest generating checking account that the money's sitting in, right? And so what happens is you file your account in an orphans court, and they set a date for what's called the audit. And the audit is when, after the account has been sent out to all the proposed beneficiaries or creditors or wherever else needs to get noticed, they have an opportunity of time to review it and say, I got a problem with this or not. And the way most counties handle it is they can show up that day of the audit and say, I have a problem with this. And then if the court feels that it's necessary and that the objection is serious, they'll list it for trial. And you can have a trial on whether or not the distribution of money is correct. And that can include things like, are you determining the shares appropriately because you figured out everyone's appropriate level of, sanguinity correctly? In other words, the bloodlines. And to avoid those type of fights, it's best to have someone who is capable and competent to do so research the bloodlines, and make sure that the familial documents are all there. If the marital, licenses have been issued and all those kinds of things, because you don't want to deal with a situation where someone says that's not a legitimate spouse, or that's not a legitimate kid, or this is a kid that you didn't even know about. That happens.
I feel like you'd have to hire a private detective to figure all that out. Are you doing that yourself?
I've hired people. I'm trying to remember the right term. I've hired people who are capable of researching the family tree, and they will get the public documents to show that the licenses were issued, that the birth certificates were issued, the death certificates were issued.
Okay.
And if it's a large family, it's probably a justified expense. If it's a rather small family where everyone knows each other, probably not. But in a more complicated case, it can be. I mean, I was proposed to be an appointed administrator for an estate where the family members are fighting over who should be in charge. And I was given some initial materials to look at, and I saw that one of the challenges before the Register of Wills is that the one child is saying the other child was never a legitimate child of the decedent. So I know that if I take this on, one of the things that I'm going to have to look into is, was there, a birth certificate? Was there ever anything that indicated they weren't the child? Was there someone else who ended up getting, parentage rights later? So that's something I'm going to have to deal with. And if people don't like my determination of whether I think it's a legitimate heir or not, there could be a trial on that. So these are things that you need to deal with in estate administration sometimes.
Is there a legal definition of a legitimate heir? Is it just blood, or is it like, if you were adopted, you would be an heir, right?
Yeah, the way the probate code works in Pennsylvania is that if someone is adopted, they are treated as a child.
Yeah.
If someone has a birth certificate saying that they were the parent, there's going to be a legal presumption they were the parent and they were the child. You would have to have some type of factual proof to contest that. Would it go as far as them seeking exhumation of a body and a DNA test? Maybe, but they probably have to pay for that. I don't think the estate will if there is legal documentation which is prima facie, valid.
Right.
So it would be like, all right, that's not really your half sister. Prove it.
Okay. I'm just curious. I know there's I think back to Maury Povich, you are not the father. So maybe they weren't on the birth certificate as the parent, but they were the actual
I mean,
blood.
that I don't know the full facts of this particular case yet. But I mean, those kinds of things come up. Hopefully that kind of stuff was dealt with during their lifetime.
Right.
I mean, if there's proof that they treated them as a child, held them out as a child, they will probably be treated as a child in distribution. That doesn't mean people can't contest that. And then it would eventually come down to what proofs convince a judge, and in orphans court it would be just a judge, that that is valid or not.
So interesting. So I want to change gears a little bit because I wanted to make sure that we got this in. When we talked before, we talked about petitions a little bit. And I do have a friend of mine that they just inherited a property, and all the family went in. So she's got like a share of it. But there's one family member that's being very difficult. And they were trying to not include this person. But then it ultimately came down, the judge said, there's nothing I can do. You guys are all family. I can't exclude him from the sale of this. So they all went in as a family together. And an option in the future, if they wanted to, is to do a petition, I think it is, but I'm not familiar with that. So can you explain to me how that works?
I'm not exactly sure what you're talking. There's a decedent's estate or no?
Yes, it is. And so the family had to purchase, they had it appraised, see what the market value was, and they had the option to purchase it at a discount. So everybody that was interested went in, and I think they created an LLC with all of those parties, or maybe they're going to, I'm not sure. But they were trying to do it without this one specific family member because he was being difficult. But then even went to court about it, trying to purchase it without him. But the judge said, there's nothing he can do there. You all have to purchase it. You all have the option, I guess is what he said.
Okay. Again, I without seeing the papers in particular, I'm not certain. I mean, it's possible that there may have been something in the will that gave people an option to purchase it, but only if they executed it jointly, or a right of first refusal. It would really depend on what the terms of the will said in this case. I'm assuming there's a will because that's not something that should come up in intestate. But good estate drafting is important because you are potentially binding the hands of the person who has to handle your estate to deal with circumstances that you thought would be good for everyone, but because of things that have happened since are not.
Right.
The job of an estate planner or an estate planning attorney, especially with wills, is to shake out the crystal ball and try and prognosticate what are all the parade of horribles of things that could happen based on what you're asked to do. And I hate to do this, but sometimes with clients, I go, all right, you have kids, and they're married, and you want the grandkids to do this, and you're hoping the kids will do that. What happens if your kids get divorced? What happens if someone dies before the other? What if just to try and deal with those situations, because if someone knows that someone in their family's got a relationship that's on the rocks, maybe they want to do some things to protect the grandchildren from the in-law. That's something that could be considered. But the caveat to all that is that people should periodically review their estate planning documents and determine whether it meets the needs and current conditions of where they are in life and who their family is and things like that. I mean, there are plenty of times where people write a will and they include very specific named people as beneficiaries with all good intentions, and then people have more children that they didn't think about.
Mm.
and didn't update their will. And then you have a situation where someone is a child who's done nothing wrong, or a grandchild who's done nothing wrong, who says, I'm not in the will. And there's going to be some presumption in law that, if you're born after the fact, you weren't meant to be excluded. Which is why a lot of times people use general terms in estate planning, such as children or grandchildren or issue being everyone down the family line, bloodline from you. Children being that specific terms of that generation immediately before you, although there is the presumption that includes adopted children. Grandchildren would be the next generation down, but also includes adopted grandchildren. And there's a lot of ways that an estate attorney who's helping you put your documents together can tease out contingencies of horrible things that could happen, just so you have an idea of what might or might not occur. Ultimately, the cold hand from the grave cannot control everything. There are certain, things that protected by law that, like the spouse's share, the spousal share. If you leave your spouse out intentionally from your will, they may elect certain statutory rights to make sure they have something to walk away from the now, deceased spouse, so that they're not left out in the cold. And that goes both ways. And then there are things that can even affect your will, like if you had certain things in a premarital agreement, because you're a blended family, and you guaranteed certain things as part of the conditions of marriage that you would do or not do with regards to your estate. So, when handling an estate, these are things that, especially it depends on the family. You have to ask questions like, were they married before? Do they have other children? Those kinds of things, so that you know what you have to deal with.
So interesting. So, you're so insightful. You've obviously dealt with some really challenging cases. What originally drew you into this type of work and helping families through these tough transitions?
My own family. As a younger lawyer, my father died young,
Sorry.
and that was multifaceted, because he was only 52. And he had a number of problems with his heart, and he was hoping to get a transplant, but it never came.
Okay.
And he had bought a house that he was going to live in with his girlfriend, and then he also had a house down in New Jersey that was more seasonal. So I ended up being his power of attorney to handle the purchase of the house, and then he died not too long after buying it. And so I had to deal with an estate that crossed state lines and had different laws apply. Before I even got to that point, he also made me his medical power of attorney, and he was very specific in life-sustaining measures. And ultimately, I had to make that decision for him when he was no longer capable. And it's not something that I relish.
Yeah.
But he was, we said it's important that you have these kind of documents regarding end-of-life decisions for your family. Because one of the worst legal fights that you can experience for its emotional toll is fighting over whether or not a beloved family member should have that decision made for them.
I couldn't even imagine. Now, you being the son and the power of attorney, did anybody from your family argue the decision or try to?
Yes. My sister ultimately accepted it, but she really resisted it. And I had to sit down with her and the doctors and really explain why there was not, long-term viability here. And I personally am of the mind that if people want the dignity to go out on their own terms, they should.
Sure.
So, it's a day that I will not soon forget. The hospital had called me the night before. They said, we don't think he can, he has sepsis and this and that. And he had a stroke. And
Oh,
all those kinds of things. And he's basically brain dead. And we can keep him on a machine, but we know he has an advance directive. My father kind of had some sense of what was coming. He had put everything together that I would need to administrate his estate in a box, like a just regular old banker's box, and he sat me down, months before this all happened, explained what everything was, told me where it was, gave me his lawyer's name. The one thing that we tried to do before he passed, and as I knew he was failing, was he wanted to change part of his will about the houses that he just bought. And I did contact his attorney to deal with that. Unfortunately, his attorney never went to the hospital, which is a lead into the issue I had to deal with that I'll tell you about in a moment. And people ask me, well, why didn't you just do his will? And I said, well, there's a very good reason for that. Knowing that I'm supposed to be the executor of the will, I'm the beneficiary of the will, and I'm his son sitting with him in the hospital, the last thing I want to do is be in a position where I'm accused of being unethical and having, some undue influence on him to change things.
Right.
So I would much rather have him have an independent person to do that. And that's something I've had to explain to some other family members over the years of, I am not doing your will if you expect to give me anything. That's just, it doesn't pass the smell test. So unfortunately, his lawyer never made it before he passed. And the day that we made the decision to stop life-sustaining measures, I remember waking up at like 5:00 in the morning, showering, putting on a full 3-piece suit to go to the hospital. Now, you don't need to wear a 3-piece suit to go to the hospital, but there was just something about, I needed to feel like I was in a uniform to make that kind of decision. I don't know how you got to talk about this, but anyway. And we let everyone know my father was likely to pass. All the family, even the ones he was estranged with, and even his ex-wife, and to their credit, they came and said goodbye. Whether he knew it or not, I'll never know. But and I, this was something else that my sister and I disagreed about. But from my perspective, it was, look, if there's any chance for him to make peace with these people, or more importantly, these people to make peace with him, this is it. So as long as people behave themselves, they get their chance.
Sure.
And everyone behaved themselves. So, and then once the estate was raised, I had the issue of how he wanted to give the one house to the girlfriend and the other house to stay with the family. Of course, no one wanted it because it wasn't close to anybody. But, I had to try and do the terms of the will. But eventually what we did is we reached a family agreement. Who was getting what? Some people got property, some people got money instead after all the expenses were paid. And that's how it was resolved. And unfortunately, in that situation, it was amicable.
That's good. I mean, it sounds like a good outcome. It also shows your passion for this and helping families out, because you have personal experience going through those motions.
So, and then after that, in the course and scope of my career, I got involved with some people who are professional guardians. And I learned a lot about, the responsibilities of guardian fiduciaries who are taking care of people who are disabled or what have you, the standards for having someone declared incapacitated and have a guardian appointed. And then through that, I ended up becoming the solicitor for an older adult protective service agency. And that is probably the most socially redeemable thing I've done in my career. We try to make sure that people are not the victim of financial exploitation, sexual abuse, emotional abuse. We try to explore least restricted, measures whenever possible so that they don't get declared incapacitated, because that does take a lot of your legal rights away. But ultimately, if it is deemed that is necessary in order to protect them, then I will take it to trial. And the last 3 to 4 years, I've tried a bunch of cases on these issues.
Wow. That's it's so crazy to me because I don't think about it, but our elders are being taken advantage of so often. So it's good that they have an advocate like you fighting for their rights.
I mean, I'm fighting for the rights, yet I'm adverse. It's a strange relationship because most people don't want to be declared incapacitated,
Hmm.
um, and I try to be sensitive of that, and I try to make sure that they are going to be kept in the hands of people who are going to take care of them. Um, but I've seen everything from people who are the victims of phone scammers, uh,
Yeah.
to people who unfortunately made someone a power of attorney who just misused all their funds for themselves, and people don't deserve it. They deserve better in their waning years. And it's not just folks who are wealthy; it is people who are just scraping by on Social Security checks and small pensions. I mean, it's shocking sometimes what people will do to their friends, family, and neighbors.
It's awful. So, I mean, everything that you do, you have to be absorbing a ton of emotional energy. What do you do to decompress?
Uh, Probably stress eat.
Oh,
uh, I mean, I am the kind of person who fights like hell in court and then goes out and gets a drink with the other attorney whenever
yeah.
possible. So, I mean, even in situations where I'm fighting another attorney in these cases, usually afterwards, we might go get a beer and decompress. And they say, look, I fought as hard as I could for my person's points, but I ultimately think what happened was right. But sometimes I lose too, and but my wife puts up with me more than probably she is should, because I definitely get into a mood when I'm getting ready for a trial where I'm just extremely focused
Sure.
and a bundle of nerves, and may not be thinking about other things. So I try to tell her I appreciate her and take her out to dinner when these things are over.
Yeah, that's nice. And it's also relatable. I feel like a lot of us can get hyper focused on our work and kind of forget about those that are in the house with us. And so that's nice. I'm sure she appreciates that being taken out and shown that.
I'm known for making a bunch of meals ahead of time before going into a trial, just so that they're there and you can warm them.
Yeah, it's good. So you said you used to be an Eagle Scout. Tell me about that.
Oh, you never stop being an Eagle Scout, but
Ew, I love that.
I had a full career in Cub Scouts, Webelos, and Boy Scouts, and I obtained the rank of the Eagle Scout when I was younger. I was in Troop 206, Northeast Philadelphia, and my Eagle Scout project was designing and building um, a more environmentally appropriate parking lot for a playground near a busy road where there just wasn't enough parking for kids to get there.
Interesting.
And we came up with a permeable surface so that water drainage wouldn't make it all mucky,
Uh-huh.
basically. And it was, like it didn't create the water runoff that asphalt would do, so that some of the stormwater issues would be a problem. And the last time I was there, it was still there after. Oh, wow, we're up to 30 years now.
Wow, that's awesome. Very cool. Are you so you're still involved with the Scouts?
I mean, it's a rank you get, Eagle Scout. I mean, I will occasionally help out the troop in my neighborhood now. I don't live where I grew up. Um, my daughters are in Girl Scouts, so I help more with that than I do with Boy Scouts these days.
Yeah, that's fun. How old are your daughters?
I have a 15-year-old and an 8-year-old, and the 15-year-old isn't doing scouting anymore, but the 8-year-old really loves it.
Yeah, that's good time. Awesome. And you also used to be on the borough council. What were your duties there?
I was elected to Lansdowne Borough Council in Delaware County. I was in public office. I can't remember if it was all on council for 14 years. I can't remember, it was 6 to 8 years as the president of council. But basically, I mean, you're a local elected official. You are running the government. I was one of 7 people. And for a good number of the years, I was the borough council president, which means I had to oversee everything and help set the agendas, run the meetings. But we were also doing things like developing the budgets, which multi-million-dollar operating budget. You had to work with other elected officials on the state, county, and federal level in order to try and get funds for your borough and special projects done, and worked on financial redevelopment issues. I was helpful in getting some grants for what's known as the Lansdowne Theater. We had a historical theater that had been closed for many years after a fire. I will not take credit as the only person who's helped on this project, but the theater finally opened this year.
Wow.
I hoped it would do it before I was out of office, but unfortunately they had more roof repairs to do than they initially thought, so their opening was delayed. But I went to bat with our county government many times for that, as well as some of our state legislatures. And we had to co-sign grants for redevelopment. So we had to do with that. And you oversee the police force, you oversee sanitation, you oversee all kinds of things. So one of the things that I'm particularly proud of was I started the Lansdowne Night Out program with the police. The first couple of inaugural years, we worked with our local police and the SEPTA police. And it became this big traditional event where everyone gets out one night in the summer and gets to meet the police and fire people, and humanizes them as much as possible with our populace. And I mean, the other side of the coin is making sure you have proper oversight of the police. So I've been involved in police union investigations and police union negotiations, as well as hiring a number of police chiefs over the terms that I've been there. So a lot of local government experience, also examining zoning, things like that.
Yeah. I love night out. So our local night out, not only there's vendors and food and of course the police are there, but they sometimes bring the police dogs. And at our local one in Hanover, we have a bloodhound, and I can't remember his name off the top of my head, but he is so adorable with his droopy face. Mm-hmm. And I just enjoy that so much every year.
We had two. One was a bomb sniffing dog, very popular.
Yeah.
They ended up getting their own baseball card because we would do baseball cards for all the cops.
I love that. Okay, so we promised folks that if they stuck around to the end of the show, we would give them a little tidbit. So could you walk us through that case where you had to obtain a judgment against that power of attorney, and what went wrong there, just to kind of explain that?
All right. I did not represent the power of attorney, first of all. All right. So the case where I talked about that had the 67 beneficiaries, it's the same family.
Oh.
So there was a couple in Philadelphia, and they were adjudicated as incapacitated. There was the Older Adult Protective Services Agency of Philadelphia, it's known as Philadelphia Corporation for the Aging, had brought a petition and had them declared incapacitated. And one of my clients, who is a professional guardian, was appointed. And being the fiduciary that he was, he looked at the finances that had been handled before his involvement and determined what he believed was that the power of attorney, who was, I believe, a niece, and I won't use names, had mishandled funds. And so he asked me to look at it. I agreed that there was an initial showing that it looked like he mishandled, that the niece mishandled funds, and we filed a demand for an account. Powers of attorney as a fiduciary under the Pennsylvania Probate Fiduciaries Estate Code can be required to account for how they spent the money. And basically, she was requested to produce the information showing how she spent the money. We did not find that it was reasonable. She was doing a lot of personal expenses with their money. She was trying to sell their house, had sold one of their other properties. There was a number of problems. And then she couldn't account for all the money. And when you are a fiduciary, you have to use the funds for the benefit of the person who, in this case, was their ward. And she just didn't do that. I mean, there was depositions taken. it turned out that she probably used undue influence in order to get them to make her power of attorney. I ended up having to take the deposition of the lawyer who prepared it. There was, irregularities in how it was prepared and how it was notarized.
Don't you have to take an oath?
Say again?
Don't you have to take an oath when you become fiduciary?
You do. Yeah.
So it's not like she couldn't say like, oh, I didn't know that I wasn't supposed to do these things. Like you take an oath.
It's when you accept the responsibility of the power of attorney, there's disclosure, at least under Pennsylvania law, there's a statement saying that you are not to use the money for your own benefit. It's supposed to be for the benefit of the person you're in charge of. And you're supposed to sign that.
Yeah.
So it's not so much an oath. I mean, if you, when you notarize something, you're notarizing something under oath saying that all the statements in there are true. And I think her acceptance was notarized. So what happened was we had a trial about how she spent the money. And I think I was going to say that it was like $125,000 that was misspent. But we literally had a trial, and she was able to justify some of the expenses and others she wasn't. And ultimately the judge who heard it entered what's called a surcharge. If you're a fiduciary, you can be surcharged for the misspending of the money in the amount of $76,000. And then what happened, and this is how I got involved in the decedent estate administration, is that after the people died, the guardian has no further legal rights to manage the affairs, right? Mm-hmm. So the guardian has to file a final report indicating how they spent the money while they had it, and to indicate what's left, and the reason why the person died, things like that. The niece turns around afterwards and hires an attorney to raise the estate. And I found out about this. And I reached out to the attorney and I said, were you aware that your client has a $76,000 surcharge against her in judgment because of how she mishandled the money while she was the power of attorney? And the attorney said, she did what now?
Oh, no.
And I said, yeah, that's the case. So he ends up withdrawing her petition to get the letters of administration because he doesn't want any parts of this.
Right.
And once that happens, anyone else who's a family member or creditor or other responsible person can petition to become the person in charge of the estate. So that's what we did. We petitioned, and the court appointed me the administrator of the estate. And one of the parts that happened during the administration is we made it perfectly clear that her share was null and void because of the $76,000 judgment.
Interesting. So, what's something that executors could protect themselves from this never happening? Like if there's one thing, you're brand new, first time ever being an executor, what's that one thing that they should do to protect themselves?
Well, there's a process built into it during the probate process itself. And sometimes when there's a will, this actually gets waived. But if there is no waiver in the will, or if it's an intestate estate and the estate value is pretty respectable, the court will require the executor or the administrator to post a bond. And the bond itself can be paid for out of the assets of the estate. It would be an expense of the estate.
Okay.
But the idea is that while you're administering the estate, that should you make some kind of error, the bond is there as a backup to replenish the funds of the estate if you make some type of serious error. When attorneys are administering the estate, as long as they have the appropriate insurance coverage, and usually this is just telling your professional malpractice carrier, I do estate administration, they will reimburse any type of professional error you make up to the amount of the policy involved, which for most professional carriers is at least $1 million and possibly more if you have excess or umbrella coverage.
Okay.
But the things, as I mentioned before, to protect yourself is, since you have a responsibility to maintain and preserve physical assets of the estate, as well as protect yourself from claims against the estate. If there is some type of property that is insurable, whether it be a boat, a car, a house, insure them. That's a big thing. Make sure things are locked up. Check on things periodically.
Mm-hmm.
If people, take an inventory early, know what everything is. Document. There is one of the issues that comes up in estate administration is, where's the will? Because a will can't be probated if it can't be found.
Yeah.
Okay. There was a time when Register of Wills would actually hold your will until you died. I don't think most of them do that anymore. I tried putting mine in my local Register of Wills, and it says, we don't do that anymore, Mike. I'm like, where am I going to put my will? So a lot of people will put them in a safe deposit box, right?
Okay.
Here's the problem. Unless someone has the key to the safe deposit box other than you, the only way you get into a safe deposit box is if you get a court order. Okay. So, and it would be a petition, what's called a petition to break. In other words, you have to file something to the court saying, we believe the will's in there and we want permission to get in it. There have been matters where people have been a court-appointed guardian, and don't ask me how, but she convinced the bank to let her in a security deposit box to gain access to the person's valuables while they were her ward. Later, it came up, and they did that without a court order, which was required even for a guardian. And she did not inventory what she took out at the time. Later, the family accused her of taking gold Cougarans out of that safe deposit box.
Wow.
And she had nothing to show that, one, she was allowed to go in it, two, what she actually took out of it. And no one from the bank was apparently present when it happened, which they should have never done either. That led to an investigation about how she handled a number of other affairs. And eventually she was hit with a multi-count federal indictment because of mishandling people's funds.
Yikes. Was that like in the 90s? Was that a long time ago?
No, this was in the last few years. She only died like a year or two ago. She died before sentencing. So
I can't imagine banks being like so wild, wild west these days.
It happens. I mean, and this was someone who was supposed to be a professional guardian. So if you're a fiduciary of someone and you don't know the law, get someone who does.
For sure.
Follow the policies, follow the procedures, document, inventory assets, secure them.
Yep.
Whenever possible, have a policy of insurance in case something goes wrong.
It's good information. You are so insightful. And I love how, you really do dive deep into it to figure out what the problem is, to come up with a solution that works for everybody. And I can appreciate that. I'm sure our listeners do too. So if anybody wanted to reach out, if they were interested in having you represent them or just learn more, how could they find you?
I'm on the website for the law firm, hillwallach.com. My email is probably harder to write down if you're watching this at home, but it's M and then my last name, Schliegh, SCHLEIGH at hillwallach.com. And my office number is 267-759-2074.
Awesome. Yeah. And we'll put that in the show notes too. If anybody didn't catch that, we'll have it there. So, oh my gosh. Well, again, incredibly insightful. Thank you so much for sharing all of your experiences and wisdom. That wraps up another episode of Bodacious Estate Conversations. Thanks for listening, and we'll be back with more great stories and tips soon. Bye.
Thanks again.
Bodacious Estate Conversations isn't just chatter. It's about learning, taking action, and finding solutions that actually work. If today's episode resonated, share your thoughts, subscribe, leave a review, and pass it along to someone who could use a hand. More stories, smart strategies, and practical guidance are coming in the next episode. Don't miss it.